Okay, good evening and welcome to the question session, questions from you regarding the assessment. I do hope by now you all have accessed the assessment. It's a bit worrying that by my last count, actually 33 students still had not even gone onto Moodle to get a look at the assessment. That aside. All right, so instructions then. It is due on the 8th of December at 2300 hours and 59 minutes. Submissions again via Moodle, obviously typed, and Word documents only, please. Don't send RTF documents, don't send PDFs. When you're naming your document, don't name it Assessment 2 or Crimproc 2 or your name. Please put your student number in there. And even on your document itself, please also reflect your student number. It's difficult. Well, it takes time for me to then, go back into the system after I've downloaded everything to try and trace who these unnamed or documents or incorrectly named documents belong to. Also make sure that your student number is put in correctly, because a number of times you guys have, through stress or whatever, put in the wrong student number. So please make sure that you put the correct student number in. You must use footnotes. And again, at the end of it all, at the very end, you must have a full bibliography or reference sheet. You must refer to case law, legislation, including the Constitution, as and where is appropriate. All right, so I'm sure you guys have had a look at the questions. What would you like clarity on? You can just raise your hand, then I can acknowledge you, and then you can mute yourself afterwards. Unmute. Go ahead, Michael.
Good evening, Ms. B.
Evening.
My first question is in light of the first question, the 30-mark question. Well, one of the 30-mark questions. Our format for in answering that question, would you like it in, because it's essentially it's like a discussion on cases, but a critical discussion. So for the purposes of that question, what format are you looking at? Do you want us in an essay format or in a potential legal opinion format, but without the me giving advice, just reviewing the law or case note format?
There's no advice really to be given, because there's no actual scenario. But the advice, in a sense, that you are giving is whether or not the removal of a bullet, in the sense, is a violation or is not a violation against self-incrimination. So even when you talk about an essay, when you essentially are writing legal opinions. So so that's the sense that you'd be following.
Okay, well, I'm just asking just because it's obviously going to be for our benefit and your benefit, because you wouldn't want us to write willy-nilly and anything like that,
Yeah, I mean, look, you must properly canvass the issues, the rule of law on what the issue is, and then make a pronouncement on what the position in the law is.
Yeah, okay. And one more thing, a question to Ms. B. I forgot how to do a case note. I know that the rest of the case notes in terms of discussing the law, but I was just wondering whether or not we were required in a case note, are we required to discuss any of the facts briefly or something?
Yes. So a case note, classically, now, if you were to look in the journals where academics write case notes, they do give a description of the case, a brief summary of the facts, but then they identify the issue. And here the issue for you is already identified, what you ought to be discussing.
Yeah.
Then it goes into the law on that issue. And because it's a case note, it discusses the way that court dealt with that issue. in terms of the law.
Okay.
And then further,
Okay.
with a case note, if you were writing for the purposes of a publication, you'd be offering some sort of critique. Either I agree, I disagree, this is why, or these were what other authors say, other judgments have said, etc. Okay, so that's also what you'd be offering there.
Okay.
And then the
So
critique,
that.
in the sense, is the advice.
Okay. Yeah, that's understandable.
Okay.
So when we're looking at a wholesome answer for this question too, um, you essentially want us to discuss that law more in light of the way that the court formulated that law in relation to the facts and applied it, if I'm correct.
Yeah, yeah. But
And
that,
then critiquing that law and saying where our position
yeah,
would
well,
be or
not,
wouldn't.
yeah, but before you even get to that stage, you'd be not only discussing how that court dealt with it, but how other courts have dealt with it. Not only other courts, but what have other academics said about this issue, and how ought the court be dealing with it, or how should we, as practitioners of criminal law, understand and interpret and apply sections 106, 1C and D. What does it actually mean? What is its
Yeah.
purpose? What is its value? Is it necessary? Why, in the broader thing being, well, why do we have more pleas? Why don't we just have guilty and not guilty? Why do we have all of these other things?
Okay. Ms. B, with regards to the word count, that's what my last question. If we run low on, if our word count is well below in terms of the word limit in, let's say, question 3, for example, let's say our word count is like 600 or something like that. Not that it would be, but if it was, would we be permitted to run over the word count a little bit in the other 2 questions, or would
No,
you?
no, 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 no. It's
Oh,
not like your whole paper must be worth 6,000 words. No.
okay,
Each
okay,
question is kept for a reason. For a
yeah.
reason. Now,
For not talking nonsense or anything like that thereafter.
yes, and
Yeah.
I've had to draft model answers for these, so I know what the limits are. So these numbers, as far as word limits, aren't arbitrary.
Yeah.
You
Yeah,
know,
definitely not.
they're not arbitrary. So if you are very much under 1,000 words, or very much under 1,500 words, I'm concerned, and you should be too, because there's certainly things that you've left out or you've not described properly or adequately. Now, if you're over, that's a bit of a double-edged sword as well, because if you're over, it could be that you're waffling, right? And that's the philosophy of, if you give someone enough rope, they will hang themselves. But the other side is that if you're over, you just had a lot more to say, more than just the bare basics or the bare bones. So it's a,
Yes,
it's a,
I
it's a
agree.
tightrope. It's a tightrope. Yeah,
Well, thank
sorry,
you
that's
so much
question
for
3. I
answering.
don't know, that's question 3, guys. Any other questions?
Miss Banji.
Yes.
Hi. I
Julie,
just
hi.
wanted to know, for our word count, would we include our footnotes in that, or is our word count for each question excluding the
Excluding,
footnote?
excluding.
Thank you.
Any other questions?
Good evening, ma'am.
Yes. Hi, Tabeka.
Ms. Anji, can I please ask if we can answer the questions in any order Like perhaps if you
Okay,
want to
here's
start
my issue with that. Here's my issue with that. This is not a sit-down exam where you're in an exam hall and an exam venue, right? You are working in an
Okay.
electronic document, which means you can move stuff around
Oh,
freely.
okay.
So if you want to start with the third question, that's your business. But when you are giving it to me, put them in order.
Oh, okay.
Does that make sense, right?
Thank you.
You can answer
Yes,
it
it
in
does.
whichever order you want. But when you're presenting it, please present it as question 1, then question 2, then question 3.
Oh, okay. Thank you.
All right, sure. One of the questions was, are we required to footnote your slides? Now, can we address this thing about referencing lecture notes and lecture slides? Can we address that? You should be getting into this type of writing where you are only footnoting and referencing things that you can raise in court as authoritative. That means textbooks, cases, journal articles. You're not going to be standing up in court and in your head of arguments write Bamji's lecture notes, Sony's lecture notes, Friedman's lecture notes, lecture slides, are you? Besides, my slides, my notes are a skeleton of that whole of the commentary of the Criminal Procedure Act that you have had access to online through the university website. Right, so let's get into, because you're not, I promise you, if you stand up in court or you present heads of arguments where you say Ms. Bamji's lecture notes, November 2020, the judge, the magistrate is going to ask you, well, what is a Bamji? How is this an authority? Right? So reference, you have to read the notes, you have to listen to the slides in the audio, but your answer, you cannot reference a summary of a summary, which is essentially what my notes and my slides are. Am I making myself clear? Do you understand why? And at the same time, though, don't just copy and paste the notes. Okay, that doesn't show understanding or demonstrate that you have grappled and wrestled with the topic. Footnote the cases as well. Footnote the cases as well, right? So that we have a reference, we have a formal reference. But once you do it once, you can then just use like Jones and then say supra ibid, whatever the case may be. Any other questions? Because my lecture notes are not admissible in court. Do you understand? All right, any other, over that now. Any other question?
May I please ask if we're allowed to consult other sources?
Of course, of
Like
course.
other.
Yes, yes. Other textbooks, other articles, other cases. You are free to do so. We have a very short semester. We have 13 weeks in the semester. And there's no way in 13 weeks that I can discuss every single case, every single article, every single chapter in every single criminal procedure textbook that dealt with a particular issue. Now I've got to do that for every single issue. I give you a summary of it all. And so, yes, in your writing, you are absolutely free, and it shows that you are engaging and grappling with the material, that you are reading and researching outside of what has merely been prescribed or recommended. Because honestly, when you get to court, when you're presenting cases in court or writing legal opinions for clients who are paying you money, and then you stand up in court and the court says, well, I see you did not refer to the case of Smith versus Singh 2022. Oh no, your worship, my lord, my lecturer never covered that case. Sorry, so I can't tell you. Okay. Okay. Question 1, should I include the facts of the case or only the reasoning? Well, you would have to give a brief summary of the case, but that absolutely doesn't form the bulk. It can't form the major part of your submission. It can't form 1,000 of your 1,500 words. It has to be a very small part. You're meant to be dealing with the law, the rule of law on that issue. So which parts of the case will form the meat of your essay and the law is what the case or cases had to say in relation to that and that. Go ahead, Michael.
Hey, Ms. B. I wanted to know, I know I've been doing my LLB for these past couple of years, but if the facts of a scenario don't elicit like evidence of one of the requirements of like a set of rule of law, so like lawful arrest or something, or lawful or unlawful arrest, does it mean that you can infer that, or do you just
What
not,
type of
and you would
question?
regard it
You're
as
talking
not
about
there?
question 3, Michael. You're talking about question 3.
Yeah.
And
Yeah.
this question is testing what? It's testing your ability to identify what the legal issue here is. So like I
Yeah.
explained, your client isn't going to come and up to you and say, my legal issue is what we're going to have to contest in court is causation, or is lawfulness of arrest, or is use of force in arrest, or is whether or not I was properly, I had a fair trial, or whether or not the judge was biased. Your client is not going to say that to you. That is,
Yeah.
you as a practitioner have to figure that out. So here you've given a problem scenario. So you've been given a set of facts. You have to identify the issue. And having successfully, only if you successfully identify the issue, can you then deal with rule of law. And that's the proper rule of law in relation to that issue.
Yeah. Yeah, I understand what you're saying, Miss B. It's just I love that this question is just so consuming. It makes you really think of whether obviously you, okay, I don't want to go into it because then students can also
Das ist ein kleiner Pinot durch.
Asking generally, what is it that is required if a question asks you to critically discuss? Critical discussion, where is that one? Critical discussion means this is what the law is. Is it correct? Is it fair? Should it change? In light of, and that means not just, oh, I think, but having consulted and referred to and looked at the reasoning in other cases, what is my opinion on this matter? Does that help? Okay, good. Any other other questions?
Sorry, ma'am.
Mm-hmm.
So this is like on that Zoom. Hi. This is that Zoom when you were speaking about like opinions and different opinions, sorry, of like different legal opinions. So you basically, when you say intrinsically discuss, so we're using maybe 3 opinions, 4 different opinions of different people, and then laying them down, and then at the end you'd give your own and say whether you agree and which way. Is that what you like mean by critically discuss? So you want to see it from different angles, what people have said about it, what the law says, and then what you say.
And at the same time, even if all of the voices are saying the same thing,
you wanna see, okay.
Yeah, basically. But it also means, well, you'd be talking about, well, not just cases, not just legislation. For that question, you're also looking at constitutionality.
Yeah.
Right? So that's
okay.
That's
Thank you.
also part and parcel of what is. Sikukele? Go ahead.
Yeah.
Yes, ma'am. I have a question.
Mm-hmm. Go ahead.
Yes, I just want to know regarding question 1.
Mm-hmm.
If we critically discuss, do we have to explain in referring to section 37? Section 37 refers to allows the court to take evidence regarding blood samples. So should we explain in detail considering the samples, or should we just go straight to the surgical removal of the bullet?
Well, that one informs the other. One informs the other. And because you're talking about the right against self-incrimination, you're going to be justifying why one is allowed and why one is questionable about whether it's allowed. So why is the taking of blood samples not seen as self-incriminatory, but why is, in one of the cases, removal of a bullet seen as self-incriminatory, if it was, right? So you be drawing those analogies. And you may go beyond that. You may then start wanting to talk about voice samples or fingerprints, I don't know, or handwriting. I don't know what the thought process or the type of argument you have mapped out to try and make. But when you're talking about the right against self-incrimination, you're gonna be necessarily talking about other forms of gathering evidence, physical human tissue type evidence, and why or why not those are or are not a violation against the right to self-incrimination. And what does that then mean? How should we actually be dealing with bullets lodged in a body? Can we include foreign case law? You can, but you must do so carefully. You must do so carefully because not all jurisdictions have the same constitutional principles and applications thereof as we do, right? Beyond that, not all of them have a process of due process, right? Which we the type of constitutional criminal procedure which we have. So when we're talking about evidence, when we're talking about investigations, it may well be very different. But yes, there are some cases which the cases in question refer to in relation to foreign law on the point. And if it helps to advance your argument in the correct way, that you are able to draw analogy not only factually, but also from a constitutional perspective, then certainly go ahead and do that.
Thank you, Ms. B. The last question:
Mm-hmm.
if we decide to explain the cases in detail, should we explain the facts, or should we just refer to the judgment in answering our or in supporting our own argument?
It depends on which question you're answering. For the ones where you're required to write a case note, you've got to give a fuller description of the facts, but like I explained, it's not the bulk of your answer. In other questions, let's say question 1, for example, you would give a much briefer description of the facts, for as much as they are, which parts of the facts are relevant to your answer. Okay, any other questions? Okay, if there are no other questions, then let me bid you farewell and wish you luck. And I look forward to receiving your submissions on the 8th of December. Good luck, everyone.